Good morning, students. I am Adv.Bhushan Bhoir. Today, our topic is bailment and pledge, delivery of goods for shopkeeping and security. So, in our syllabus, there is an important aspect that is bailment and followed by pledge. So, first of all, we will see the bailment. Bailment means delivering into section 148 to 181 of the law. This present the definition of the bailment. Bailment is a contractual arrangement where one person, the bailer, delivered goods to another, the bailee, for a specific purpose. Upon the fulfillment of this purpose, the goods are either returned to the bailer or disposed of according to the instruction. So here we see that there are two parties, one person who is delivering the goods and other person who is received the goods. So the important thing we should remind that one person who is delivering the goods is the owner, and those who is receiving the goods is not receiving the ownership. They are just receiving the goods for the bailment. The core of the bailment is transfer of possession, not ownership. Very important aspect. The it always arises from the contract, either express or implied. Express contract means where all the details are being mentioned, and implied contract means where detail are not mentioned but the laws regarding contract are applicable to the bailment. Section 149, mode of delivery in bailment. So there are two types of delivery. First one is an actual delivery, and then second one is a constructive delivery. The actual delivery is they involves the physical transfer of goods from one bailer to the bailee. It's direct and tangible handover. And the other one is a constructive delivery. Here the physical transfer does not occur, but something is done that has the effect of putting the goods in the bailee's possession. This implies control over the goods. Crucially, in both form of delivery, ownership of the goods remain with the bailer. Only the possession and control are transferred to the bailee, that is another person. Section 50, bailer duty to disclose the fault. It is duty of the bailer to disclose all the faults regarding the goods. A responsible bailer must disclose any known defects in the goods that could pose an extraordinary risk or cause damage to the bailee or their property. This duty ensures the bailee is aware of potential hazards. So, undisclosed defect, if the bailer fails to disclose such faults, they become liable for any resulting damages or injury. So whether there is injury or anything happen to the bailee, bailers are responsible for that damages. Safety first. This section underscores the importance of transparency in bailment agreement, particularly concerning the safety. Example is been given. If Mr. Green lends his horse, known to its unpredictable temperament, to Miss Brown without warning her, and then horse causes injury, so Mr. Green is liable due to the failure to disclose the known fact. Next section 152, 1, Bailey's duty of care. Reasonable prudence. The bailee is obliged to take as much care of the bail goods as a person of ordinary prudence who will take of their own goods under similar circumstances. Zero liability for accidents. If the bailee exercise this level of due care, they are generally not held liable for any loss, destruction, or deterioration of the goods that occurs due to the unforeseen circumstances of accidents. For example, a parking garage bailee must ensure reasonable security and protection for the vehicle of goods entrusted to its care, just as a car owner would for their own vehicle. So the liability of bailee is there to protect or to take care of the goods, bail goods. 153 section, Bailey's liability for servants. A bailee is held liable for any loss or damages to the bail goods that result from the negligence of their employees, provides those employees were acting within the scope of their employment. Employee action. The bailee assumes liability for the actions of their staff who handles the goods. And third party act, if the other person is involved in that transaction. However, the bailee is typically not liable for the act of the third party if they have exercised ordinary diligence in protecting the goods. Example, warehouse damage. If a warehouse employee accidentally damages store goods while operating a forklift, the warehouse, that is bailee, is liable for the damages because the employee was acting in the official capacity. The section 160, that is a bailment types, that is first one is a gratuitous bailment and second one is a bailment for reward. Gratuitous bailment means free of cost services, free of cost transfer of goods. This type of bailment involves non-payment or compensation. The service is provided out of goodwill and friendship. For example, if someone lends his bike to his friend and without consideration he is lending that bike to his friend, so that transaction, that contract is called a gratuitous bailment. Lending or loan mower to neighbor free of charge. And second one is a bailment for reward, or we can say that non-gratuitous bailment. In this scenario, the bailee receives payment or some form of compensation for taking care of the goods or performing the agreed upon the services. Whenever we take something in a return for a bailment, it is called a bailment for reward. Next, pledge. Bailment. The bailment is done. Now the another aspect of bailment is a pledge. A pledge is a specific type of bailment where goods are delivered by a pledger to a pledgee as a security for the repayment of a debt or the performance of the promises. Simple example of this concept is a gold loan, where we go to the bank and ask for a loan by keeping a security of our gold. So that is called a pledge. Possession as a security. The pledge retains possession of the goods until the debt is repaid. Means when we pledge our gold to the bank will keep that gold until and unless we pay our loan back to the bank. Right to sell. If the pledger default onto the debt, the pledgee has a right to sell that pledge goods to recover the outstanding amount after giving due notice. So if a pledger failed to pay the amount, then the bank or the pledgee will sell that goods. For example, pawning or jewelry. Pledge a gold necklace to a lender for a loan. The necklace acts as a contractual until the loan is settled. Now the main difference between bailment and pledge. First point, purpose. Bailment, goods delivery for safekeeping, repairs or transport, no financial transaction implied. Pledge, goods services specifically as security for a loan or promise. Then second point is a financial implication, where first point is held. Bailment may or may not involve payment, gratuitous or for a reward, but for pledger there is always a consideration, always involve a financial obligation, a debt or a promise. Third point, right to sell. Bailment generally has no right to sell the goods, but in a pledge, if one person fails to pay the amount, then a pledgee has a right to sell their goods. Now conclusion, importance of bailment and pledge of law. First one is a protecting rights. This legal framework clarifies the defined rights and duties of the parties involved in temporary transfer of goods, ensuring fair practices. There should be a proper transaction, proper contact of a bailment when one person is delivering the goods to other person, and for that contract other party will surely pay the amount. In bailment there will be amount to be paid, but in a pledge, contract of pledge, the amount should be paid. Legal framework. They establish clear guidelines for the possession, care and the eventual return or disposal of goods, preventing disputes. So if the bailment contract or pledge contract is been done previously, then there will not be any disputes occur in this aspect. Real world impact. For the leaving your car at a valet to secure a business loan with a collateral, this law underpinned countless daily transactions. Safeguard internets. Understanding these sections is a vital for safeguard both business and personal property interest is divert commercial and personal contexts. Thank you.